Good afternoon, everybody. Today we have the pleasure of hearing again from Marshall Waters, the Director of the Division of Real Estate here at DORA. And this is her third installment of the Directly from the Director series. And it's going to touch on, again, important issues for the real estate broker community. Today's installment is going to cover adverse material facts. And we did survey questions in advance from the attendees that will be discussed today. And we will have some additional time after the presentation. We can address more questions at that point. And you can also ask questions in the chat feature, which is in the system below that you can see the hand or chat. We'll be recording today's presentation, so don't worry if you miss something or you have friends that want to watch it later and associates, we can do that. And we will be sending out that recording link along with the slide presentation in a email blast to the brokers. Also, we want to let you know we've created some division web pages to discuss issues from these presentations, the past ones and today's, and they're going to be referenced on the slide at the end of the presentation. So I want to thank you for attending today's event, and I will now turn over the presentation to Director Waters. Director Waters?
Well, I thank everybody for tuning in. This has been one of the leading issues that we see as far as public complaints that are filed with the Real Estate Commission against brokers is the disclosure of material facts. And regardless of how you're representing somebody in a transaction, whether you're a single agent or a transaction broker, the license law requires that you disclose any adverse material facts that are actually known to you as a real estate broker. So when we get a complaint in about adverse material facts, number one, we're trying to evaluate, was there information that the broker should have known? And then number two, did you fail to disclose? And we do get a lot of complaints where the allegation is, you know, I purchased this property or I moved into this property and then I discovered that there was a mold issue or there's an issue with radon or some other material fact. And right away they make an accusation that, well, the broker knew this and didn't disclose it. Unless they have some information to really show us how the broker knew it, we don't necessarily assign those for investigation. We have to have something to go on. And a lot of the time with the material facts cases, a lot of the complaints that don't actually get assigned for investigation, pretty much the accusations lead more to it was the seller's knowledge, not necessarily the broker's knowledge. And with a real estate commission complaint, we are strictly looking at the activities of our licensee. So a seller's duty to disclose is not something that we're going to deal with unless that seller also happens to be a licensed broker. And so today, as we go through and kind of discuss the obligations and some of the issues that we see, we've got a few case studies for you. We're going to be focusing strictly on commission actions, not on civil litigation. That's typically not something that at the division level we really concern ourselves about. It's how our commission responds to violations of the license law. So with that, Gary, if you want to advance to the next slide, a lot of what you guys have to deal with as far as when you're going through with the disclosure of material facts is, number one, what is a material fact? And material fact is information that a reasonable person might find significant. And another factor to consider is if the person had the information, would it have altered their decision? And I think really, particularly in these times, it's probably more difficult to define what a reasonable person is than actually a material fact. So the other thing that I would impress upon you as a real estate broker is it's not your duty to decide what is or what is not pertinent to a consumer. You need to disclose the information, and then that way they can make an informed decision, and they should be left to make that informed decision. So just bear that in mind. Disclose, 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 err on the side of caution, and that will probably save you should there be a complaint that comes in. So I'm sure all of you are well aware that we have a seller's property disclosure. This is a form that is for the seller to complete. It's not for the broker to complete. And I know that there's questions that come up when the sellers are completing those seller property disclosures, and our brokers want to be helpful, but you also have to be cautious that you're not overstepping your bounds as a real estate broker and then providing legal advice. So Really the sellers also need to err on a side of caution. They have a duty to disclose material facts. They also have a duty to disclose latent defects as well. And a latent defect is a fault in the property that you otherwise probably would not be able to identify through a reasonably thorough inspection. Usually a latent defect is something that is hidden from view. So as they're going through and filling out the seller's property disclosure, they should also be erring on the side of caution. If they knew that there was a water issue that involved a leak, they can add notes elaborating, or if something's been mitigated, they can elaborate that as well. When they fail to make a disclosure, they're not dealing with the real estate commission. They could be dealing with civil litigation. So they need to be well aware of that. And also, the other thing that the sellers need to be aware of is that during the course of the transaction, if there are material facts identified about the property that weren't originally identified on the seller's property disclosure, you then have to, on a go-forward basis, start making those disclosures as well. So your seller's property disclosure should be updated, and you as a broker now have to disclose those facts also. And the other thing that we'd made sure to do with the seller's property disclosure, to put the sellers on alert, because I know in the 15 years that I've been at the division, and I started off as an investigator, and I also was a broker briefly prior to that, you've got sellers that are like, well, we had this issue, but I don't want you to bring that up. Well, you're required, if it's a material fact, to disclose it. And the fact that they've now told you about it, you're going to have to disclose it. And it often puts you in a difficult situation as well. And that's why we really put the alert at the beginning of the seller's property disclosure. It says in the first paragraph that any changes must be disclosed by the seller to the buyer promptly after discovery. Seller's failure to disclose a known material defect may result in legal liability. So you don't get to violate the law for them, and they need to be aware that you've got that duty to disclose. So that's part of the reason that that was put into the seller's property disclosure. I know that through the course of the different cases that we have dealt with over the years, it also happens though, where if you've had multiple deals where a property's gone under contract a couple times and you get conflicting inspection reports, then the question becomes, well, which one do I disclose? If you have two conflicting inspection reports, based on commission action, you need to be disclosing both of those. And then that way, the person can make an informed decision. They should be having their own independent inspection done. But it's not your job to reconcile the information. They need to figure it out. They need to do their due diligence. And as kind of an example case, we had a real estate broker. It's been a couple years ago. She was the listing agent for a property. Deal number one came in. There was an inspection done. The inspection identified issues with the foundation. The deal dies. Buyer number two comes in. They go under contract. They have an inspection done. Their inspection does not identify issues with the foundation. Then, for some reason, that transaction failed as well, and now you get buyer number three. Well, the broker only disclosed the inspection outcome from buyer number two that said there were no foundation issues. Buyer number three closes. There are foundation issues. Buyer number three files a complaint with the real estate commission alleging that the broker failed to disclose a known material fact. We were able to basically prove the allegation that there were two inspection reports, only one was disclosed, and the real estate commission ended up disciplining the broker for not disclosing both of the reports. So based on the commission action, that is how you're supposed to manage that, is you should be giving the information from both of those inspections. And you don't always have the inspection reports, but if there's issues identified, you need to be disclosing that. The buyer needs to do their due diligence, and they need to make an informed decision and decide whether they're going to move forward or not. So along with adverse material facts, another thing that you guys have to deal with is stigmatized property. And you don't have a duty to disclose facts or suspicions surrounding a property that may deal with a person that has been or is believed to have been infected with HIV or diagnosed with AIDS. There's other diseases or viruses where transmission is not going to prove to be necessarily a health hazard relating to occupancy of a dwelling. or that the property has been the site of a homicide, suicide, or other felony. The important thing to remember, though, about stigmatized properties is it's not just confined to HIV and AIDS or a suicide, homicide, or felony. The statute says include, but not limited to. So one of the things that we noticed that came up with some of the questions that you guys submitted with your surveys had to do with ghosts or just people dying in the property. One of the first complaints that I got when I was an investigator with the Real Estate Commission, and my boss at the time had far more excitement for some of my complaints than I did, but it involved a complaint that the broker failed to disclose that the previous owner had died in the property. And the complaint had said, you know, the broker didn't tell me that the seller had died in the property and he had died on my side of the bed. And now every time when I try to watch TV, the TV shuts off, and it's because the ghost doesn't like what I'm watching on TV. So I'm not really sure about the whole dying on the side of the bed, because it makes you wonder, did you also purchase the bed from the previous owner? But the fact that the seller died in the property was not something, as far as the commission was concerned, that the broker had to disclose. Now you've got the allegations about a ghost, and not everybody believes in the paranormal. What I do believe was happening, though, is that this particular complainant, they were grandparents and they had their 12-year-old grandson living in the property with them. What I think was happening as far as the TV shutting off, strangely, the 12-year-old was never in the room when the TV was shutting off, and I think he was playing a joke on his grandparents to make them think that it was actually haunted by a ghost. So the commission, we haven't gotten too many ghost complaints, but in that particular scenario, the commission dismissed the complaint against the real estate broker, finding that he didn't have a duty to disclose that there was the previous owner's death in the property, and they really didn't see any validity to the ghost claims. So Gary, do you want to go on to the next slide? And this will kind of start our case reviews. Okay, so this has been kind of unique. We don't see cases involving endangered species come into the Real Estate Commission very often. This case came in, it's been quite a while ago. It was about 15 years ago. And the scenario was, so you've got a developer who is doing a development in the Larkspur area. And these are typically 35-acre lots. It's a project that involves also a man-made lake. And I believe they started the development in 1999. So the managing member of the developer is a real estate broker, and then his wife is marketing these properties to consumers. So when they had started the development back in 1999, the Army Corps of Engineers had actually come in and kind of put a halt on their development to say, you know, you're in an area that is habitat for the Preble's Meadow jumping mouse. We need to do some actual studies to make sure that you don't have the endangered species in your development. They ended up hiring a consulting firm. The consulting firm put out traps to see if, and these were safe traps, they didn't kill the endangered species, but they put out traps to see if there was the presence of this endangered species on the property, and lo and behold, they end up catching 2 of the Preble's Meadow jumping mice. And for this, I'll give you some foreshadowing. Both of these mice that are captured are located on what is going to become Lot 16 of this development. So what it amounts to is, because the Army Corps of Engineers and the U.S. Fish and Wildlife Service are now involved and dealing with an endangered species, they have a list of requirements that the developer now has to deal with. And one of those requirements is this Lot 16 should not be used for development. What happens though instead, and also the developer was supposed to be recording deed restrictions, there was mitigation factors that would come into play as well, but definitely no building on this Lot 16. Well, in 2000, our complainant purchases Lot 16 for $200,000, and it's a 35-acre lot. There was no deed restriction actually recorded. Her primary reason for purchasing this 35-acre lot was she was actually going to run a business off of it. She wanted to use this property not only for her residence, but she was going to construct a guest house and a barn. and she was going to have some livestock on the property. It was going to be kind of used for children's parties, and I think she was also going to kind of run a petting zoo on it. So totally incongruent with the restrictions that the Army Corps of Engineers and the U.S. Fish and Wildlife Service had placed on the property. So it took her a while. She didn't do any development for a while, and there were some issues as far as her lot lines were concerned. And the developer at one point said that he was going to readjust her lot lines so that she would have more frontage to this man-made lake. And what she finds out later, though, after she's closed, and it's not until 2004 when her neighbor constructs a barn on his property, that the Army Corps of Engineers and the U.S. Fish and Wildlife Service come in and tell them that they're in violation. And our complainant finds out that she has purchased what should have been an outlot. It should have never been used as far as trying to develop anything. It shouldn't have been sold. So she's out $200,000. She's got a property that she can't do anything with. She definitely cannot do anything that the developer had represented to her as being able to do, because he had told her, yeah, you can build a house, a barn, a guest house, you can have a garage. The requirements for the subdivision was the minimum building input or footprint. She had to have at least a 2,000 square foot house on it. She's not even able to do that. Of the 35 acres that she had, ultimately down the line, when they were able to kind of work with the Army Corps of Engineers and the U.S. Fish and Wildlife Service to try to mitigate the impacts of this endangered species on her particular lot, she had a 35-acre lot that she purchased. She was only able to use 0.05 acres. So she ends up filing the complaint with the Real Estate Commission. And I will tell you, with a lot of our material facts cases, we will go back and forth between the complainant and the respondent, and we've got the he said and she said. But in the cases where we're able to successfully prove that there has been a failure to disclose, we always have somebody that has taken meticulous notes and can tell you when something was disclosed, how it was disclosed, and why it was disclosed. And that's where the Army Corps of Engineers and the U.S. Fish and Wildlife Service come into play. Plus, we did extensive interviews with the other people that purchased lots within the subdivision, because there were a lot of people that ended up having impacts from this endangered species. And there were some very hard feelings as far as between them and the developer as far as disclosure was concerned. They also, a lot of the sentiment that came through, another material fact that wasn't disclosed was this man-made lake was actually had a leak. So it couldn't be used as this water ski lake as originally represented. So the Real Estate Commission had voted to take the licenses of the developer who was licensed as a real estate broker and also his wife that was marketing the property. But the complainant also did pursue civil action, and she ended up winning in the civil action. She got her $200,000 back for what she purchased that property for, along with an additional $25,000. I don't know that she would necessarily feel like she was made whole, given the amount of heartache that she had to go through. I mean, it was 5 years of having a property that she couldn't use, and it impacted her income stream. So that is the endangered species case that is kind of on record with us. And like I said, we don't see too many of those. So Gary, do you want to go to the next one? So I was fortunate to not only did I get the ghost case 15 years ago, but I also got our first meth lab case. And strangely, a lot of you know that I used to be a police officer. I got our first meth lab case when I was a police officer. I started to wonder if this was a horrible trend. But fortunately, this was the only meth lab case that I've gotten at the division. We have gotten other ones. So with this particular case, to give you a little bit of a background, the listing agent goes on a listing appointment. She deals with Mr. Seller and Mrs. Seller. And Mr. Seller had been arrested a year prior for manufacturing methamphetamine in his garage. And Mr. Seller used to work for a local supermarket pharmacy. And this is how law enforcement got tipped off. In his pharmacy job, he was purchasing large quantities of Sudafed. So they're tracking these purchases. they're able to get a search warrant and search his property, and they find the clandestine methamphetamine lab in his garage. The neighbor across the street has watched all of this unfold, so she's aware of what's been going on at this house. And when Mr. Seller had his home searched and was later arrested by law enforcement, he gave them this unbelievable story that he was conducting stem cell research in his garage, and that sometimes when you do stem cell research, it produces byproducts also indicative of a meth lab. So the two byproducts are ephedrine and methamphetamine. Law enforcement did not believe this kind of cockamamie excuse. He's arrested. When the listing agent goes out on the listing appointment and takes a listing, Mr. Seller is actually on his way to prison. So that's another red flag that you might want to ask, hey, you're going to prison. What are you going to prison for? So she has the sellers complete a seller's property disclosure. Big surprise, there is nothing on that seller's property disclosure that there was ever a meth lab on the property, any toxic chemicals, not subject to legal action, nothing's disclosed. And the listing agent, so we got this complaint in during the course of the sales transaction because there is a buyer that comes in, and it's the buyer that actually submits the complaint to us about the broker failing to disclose that her listing's a meth lab. So the listing agent claims from the beginning that the seller has told her that the only thing that was happening at the house was that he had a chemical lab that was fully enclosed and that was in his garage. And according to this listing agent, she didn't think anything of that because she had previously listed properties where, you know, the seller's children had science labs in the basement or something. So picture third grade when we all had microscopes and we're looking at amoebas under the microscope slides. Somehow that's the correlation that she draws between a clandestine meth lab in the garage and kids with microscopes. So as soon as she plants the yard sign in the yard, fortunately the neighbor across the street who has knowledge of what has gone down with that property over the past year, immediately contacts the sergeant that was in charge of the investigation with the West Metro Task Force and lets him know that the property is now on the market and that there's a sign in the yard. So that sergeant immediately contacts the listing broker and lets her know, listen, that is the site of a meth lab. You have got to disclose this, and it's a requirement. So she doesn't really take the sergeant's information as accurate, and all she is doing is saying, well, the seller said that he was doing some scientific research at the house. The home may have been subject to a drug investigation. Just call the listing agent. So in comes the buyers, and the buyer's broker right away asks the listing agent regarding the MLS remarks that she's got about may have been a drug investigation. He specifically asks, was this a meth lab? And the buyer's agent is told no. The listing agent tells him that the seller was doing stem cell research in the garage and that he was previously a pharmacist. So they go under contract to purchase the house, and the buyer starts doing some due diligence on their part, and fortunately comes into contact with the sergeant at the West Metro Task Force, who tells them that no, that was the scene of a meth lab. The person was arrested and charged. He's going to jail. So what they end up doing is they end up drafting some language about the inspection saying that if it does test positive as a result of an industrial hygienist coming in and running testing, that the seller's going to have to mitigate the impacts of any methamphetamine. And they're going to have a follow-up test to make sure that the property is now testing for safe levels. And I don't think really at the state level they still have identified what a safe level is, but there was at least some assurance that something would be done to mitigate this property. So the industrial hygienist goes in and tests the property, and lo and big shock, the garage tests positive for methamphetamine. The estimation as far as the cost of mitigation, they're told it's going to cost between $10,000 and $30,000 to mitigate the meth contamination in this property. Well, the seller cannot afford that, and the deal dies. So the buyer's out of contract. The concern was, though, is as part of this investigation, you've got a buyer, and they had originally submitted an offer to purchase this property for $335,000. Because the broker was not upfront and truthful about the meth issues, and I can't think of a better source other than law enforcement to tell you, no, that was a meth lab. They felt that that listing broker put him, his wife, and his future family in danger of tremendous health risks. So after the deal dies, the listing broker modifies the MLS language again. She's never come out as being completely upfront about it. So what she says now in the MLS remarks is subject to drug investigation, meth lab, according to the police, call listing agent. Eventually, this property was taken off the market because nobody was going to purchase it without it being mitigated, and the sellers finally did elect to mitigate it. Hopefully, they were involved in an industrial hygienist. But that was the commission's first meth lab case. The broker did end up getting disciplined. The commission did find that she failed to appropriately disclose the material facts related to meth. Okay, Gary, you want to go to the next one? So one of the things, this is our final kind of case study. I would definitely caution you to not try to conceal material facts when it is your own property and you are a licensed broker, because it does not work out well at all when those cases go to the real estate commission. And this is another really good example of, we start off with a complaint that's a he said, she said against complainant and the complainant who's the buyer and the respondent who's the seller and the broker. And then we end up with kind of our star witness that has meticulous notes. So this involves a property that it was built in 2002. The real estate broker, who's Mr. Seller, has lived there since it was constructed. So 2002, he decides to sell it in 2010. But prior to selling that, according to the broker, in 2006, he had noticed that there was some shifting problems and what he would call minor cosmetic cracks. So he starts seeing cracks in the drywall in a couple of the bedrooms, but also in the downstairs hallways and in the stairway. The home was still under builder warranty, so he contacts the builder. The builder comes out and they hire an engineering firm to actually do an assessment. And while they're assessing the property, one of the things that they note is that there's a grading issue on the west side of the property related to the landscaping, and it's causing water to pool and it's causing swamping conditions near the foundation of the house. But also what's determined is that the builder needed to go in and make some pillar adjustments in the basement, and also to redo the drain that goes around the house. And in dealing with the pillars in the basement, some of the other things that have to occur is the builder is having to remove parts of the basement floor and then re-pour the concrete support pads. So this is not a simple, quick and easy repair by any means. The repairs are made, the builder then comes out, and one of the things that the builder had said needed to occur based on the engineering reports was that every 6 months, there needed to be an assessment of this property to see if there's any more settling issues or drainage issues. But after they made the big repairs in 2006, the builder also comes out and deals with some of the landscape grading and also dealing with the cosmetic repairs that were a result of the settling issues. So they retexture and paint the house to deal with the cracks. And the broker claims that, this issue back in 2006, he thought fixed the issues and that they weren't considered major structural issues. And then he also claims that prior to selling the house, which he does in 2010, that the builder came back and did some more cosmetic repairs. But according to the broker's recollection, the only issue as far as the pillars were concerned, that was back in 2006. So during the course of the investigation, the investigator reaches out to the builder And we find that there's a different chain of events than what our respondent has given to us. So he is correct that the first issues were identified in 2006. And when the broker and the engineering firm, and there's actually 2 engineering firms involved in this case, when they go out in 2006, what they identify is there's 14 measurable drywall and grout cracks on the first and second floor. There's problems found with the first floor joists. One side of the house has shifted due to soil expansion. And this is now causing the cracking of the drywall, the grout, and there's misalignment of the doors. And they determined that the interior columns need to be readjusted to the level of the house. The concrete pads in the basement had to be removed and repoured. The house would need to be closely monitored every 6 months, and they may need to adjust the interior columns each time they come out and when they do the assessment. And they also determined that grading needed to be done to increase the slope away from the house. So based on these identified concerns, the repairs were made in March of 2006. The builder and the engineer do follow-up inspections every 6 months after that. In 2007, the builder recommended some cosmetic repairs to the drywall, the texture and painting in the house be made, which they did complete. Now in 2008, new cracks on the drywall are identified in various locations of the house. And the builder and the engineer identify that more adjustments to the interior columns and the pads in the basement need to be made. They also need to do more grading of the landscaping so that the drainage is away from the house. And these issues were reported to the broker and the broker owner back in 2008. They made the repairs in December of 2008, and then cosmetic repairs followed that after they fixed the structural issues. And again, they continue to monitor the issues with this property. So in July and November of 2009, additional reports are issued by the engineer. The November report indicates that the broker had identified additional areas of minor drywall stress and an issue with the master bedroom door. So again, they determined that the interior columns need to be adjusted and the concrete pads have to be resized and replaced. There's another engineering report that is issued in March of 2010, and this has the most drastic repairs to date for this property. So now they're saying that the basement interior footing pads need to be replaced, all exterior concrete pads, front entry concrete sidewalk, and a section of the driveway need to be replaced as well. There's more grading of the soil around the house that needs to occur, and there's going to have to be cosmetic repairs done once they fix those issues. And so the broker was notified of this report and the issues on March 25th of 2010. At this time, the broker notifies the builder that the home is up for sale and there's a potential buyer. And he'd asked the builder to issue a letter to the buyer indicating that the repairs would be covered under the builder's warranty. And the builder does issue this to this initial buyer. And the letter is issued on April 27th of 2010. Because of the issues and conversations that were going on between the builder and this potential buyer, eventually this buyer decides to back out of the transaction, and the broker is agitated with the buyer at this point. And he's basically telling the builder that you are making it impossible to sell this house because of these issues. So the builder and the broker owner meet in June of 2010 to discuss the work that needs to occur to the property regarding the structural issues. They give the broker a detailed report about what is going to be done. The repairs are made. And then you've got a new buyer that comes into the mix. And this buyer isn't told about anything regarding this property. So, after the issues are fixed, probably in about July of 2010, the engineering firm and also the builder are trying to do a follow-up visit to basically check on the status of the property, and the broker has gone completely dark. He is not responding. So what happens is, because he's not responding to them, they end up leaving a door knocker on the front door of the property to notify them, hey, we need to talk to you about doing this follow-up inspection. And that's when they are introduced to the new buyer, who has closed on the property and moved in and didn't know anything about the structural issues. So basically, out of the outcome of the investigation, we find out compliments of the builder, everything that has happened, that the broker has been fully informed about this. You've got a broker who is our respondent that says the only issue was minor stuff, cosmetic stuff from 2006. And you've got a buyer that basically is telling the real estate commission that if he'd known about the issues, they would have never purchased this home. What the commission decided to do with this particular broker is the maximum that a real estate commission can do to one of its licensees is revoke a license and impose maximum fines. And that is exactly what they did with this broker. So he definitely serves as a cautionary tale for all of us that have broker's licenses, that at some point will sell a property or we'll have to deal with a material disclosure. I do think that the real estate commission holds you to a higher standard as far as an expectation of, well, you're, by virtue of your broker's license, where another seller may try to conceal something, they are definitely show no mercy when it's a real estate broker trying to conceal material facts about one of your own properties. So he is definitely kind of the poster children on, if you don't want to have a license, this is how you behave in a real estate transaction. So those are our 3 case studies. I know that Pat is going to join on camera, and then we're going to go through some of the questions that you guys submitted when you signed up for this webinar. So Pat, do you want to take it away?
Absolutely. Thanks, Marcia. Those are great stories. It's amazing how often there were multiple buyers, and so this fairly complete record of what had happened in the past. Just so everybody knows, we did have some folks who presented questions at the time that they signed up, and we've got a bunch of questions that have happened so far this afternoon. We're going to hit as many of those as we can. So let's just jump in. There were a bunch of questions when you were talking about previous inspections. And so, for example, in some cases, a listing broker has said, it appeared that the buyer was just using the inspection process because they wanted to terminate the deal. And so that sole subjective discretion, they were able to get out of the contract for the inspection objection. They gave them their earnest money back. But this listing broker is saying, why should my seller be, in my seller's property, be sort of stigmatized or have to disclose information? We don't really think the inspection report was that accurate, and we believe the buyer was really just trying to get out, which we let them do. So can you maybe speak to how the commission might view something like that?
So based on what we've seen just by virtue of complaints, even if you don't necessarily believe that there's an issue, if that is a reason that they have basically terminated the deal, if they're claiming, well, the radon levels are too high or there's mold in the property, and it's based on an inspection, I would still be disclosing that, they're claiming that based on the inspection that they had, that there is this issue. I would recommend that you do your own due diligence, which hopefully they are. I think the fact that people waive inspections, that's another issue where you just basically need to cover your end to make sure that you counseled them to get one, and then they refuse to do that. But you're still going to have to reconcile whether you agree with the findings of an inspection or not. That's been a finding. And if somebody's used it to terminate a deal, I would be disclosing that just based on prior commission actions.
And kind of on a related note, some folks are saying the inspection came over, but I didn't look at it. Or the buyer's broker asked if they should send the inspection. I told them, no, I don't want to see it. Does that absolve the listing broker from having to disclose anything?
So you don't have to actually get a copy of the inspection report. If they're identifying issues it's coming through on the inspection resolution, or they're using it as a termination, you're still going to have to deal with the fact that those are issues that have now been raised about the property. This whole concept of, and it's not just with an inspection report, I've also heard it with title commitments. that as a real estate broker, you get a copy of this document, you're just not going to look at it because you don't want the liability, so you just stick it in your file. And I think in those type of situations, what you're going to deal with if you go in front of the real estate commission is you're not performing your brokerage duties, because you should be alerting people to the issues within those documents. I mean, if something comes through on title that's going to affect their ability to use that property, you should be flagging that for them. I would not be giving them legal advice about it. But I would say, you know, I found this in your title exceptions, you need to talk to an attorney about the impacts it's going to have on your use of the property. And so if there's an issue raised in the inspection report, ignorance is not going to give you an out with the real estate commission.
And there have been some folks who have said that they didn't feel like they could give the subsequent buyer a copy of an inspection report because it belonged to the buyer. The previous buyer, buyer number one, was the person who paid for it. And so they can't give it to buyer number two.
Well, but I think if buyer number one has provided a copy to your seller, as far as I know, that those are not protected documents anyhow. So the seller's now going to have to deal with having that document. And I don't think that there's any prohibitions that on the seller as far as releasing them.
And when somebody lists a property as being sold as is, does that change anything about the disclosure requirements?
You still have to disclose any known material facts. As is should put people on alert that basically the seller is not willing to make any repairs. You were purchasing it in the condition that it's in currently.
But it doesn't necessarily change if you know something, like if the broker knows something exists there.
You still have to disclose.
Okay. And what about, so we've had some questions about if the defect is quite obvious. So if there's an obvious crack in a basement floor and the broker says, I didn't disclose that because all they had to do was look right at it. Does the degree to which the defect is hidden, does that matter?
So I think that's a factor that the real estate commission would take into account, you know, whether something was obvious or not, but you have to evaluate the abilities of the consumer that you're dealing with. So really I would be erring on the side of caution, and even though it would appear for the average person to be obvious, I think that speaks to what I said earlier about reasonable person. I would just go ahead and err on the side of disclosure and point out there's a crack in the basement floor.
And kind of on a related note, there was a question about if the potential defect, for example, the example they gave was within the HOA documents. If, for example, a reserve study shows that the HOA does not have sufficient reserves, and that's within the documents, if the documents are sent, does the broker who knows what's in the document have to point that out, or can they just send the docs and call it good?
Well, so there's several factors with this one. Number one, we're going to ask the consumer, did you read the HOA documents? Did you see it in there? But also that person's broker, we're also going to be asking them, did you review these documents? Did you flag this for them? Because the real estate broker has a duty to advise the person through the transaction so that they can meet the terms and everything else. So you're not supposed to opine on things that are beyond your level of expertise, which includes don't practice law without a law license. But you should be drawing attention so that they are aware of those things, because you kind of have to manage it to the lowest common denominator and expect that a lot of people are not very sophisticated about reading HOA documents. Do they understand reserve studies? You're kind of there to nudge them so that they know when to ask questions.
And so if we got a complaint like that, what do you think the investigator would be looking for to say, so that the broker could demonstrate, yep, I said you ought to take a look at this. I flagged this for them.
Well, I think we would be looking at it more from the buyer's agent's perspective of what did their broker do to fulfill their brokerage duties. But but it is pretty often that we will get a complaint about, well, I didn't know this when I closed on my transaction. And we do ask questions about the obvious. Did you read your title commitment? Did you read your HOA declarations? And I think to some of the extent of, if they say like, well, no, I didn't, or the commission then has to kind of evaluate the difference between the broker's duties versus the individual principal's due diligence duties. And so I don't think these types of cases aren't very cut and dry necessarily. We do get a lot of complaints about brokers not disclosing HOA related issues. But to some extent, the consumer has to do their own due diligence as well. And if it's there, in black and white in print, that may actually help bolster a broker's case that, that the buyer didn't do their due diligence.
And so if I'm a buyer's broker and I have an email that says to the buyer, please see the attached, make sure you review those documents because there's important stuff in there, is that enough to sort of demonstrate that I've at least alerted them?
So, well, and I can't think of a real estate commission case that has gone in front of the commission where they've taken action with kind of a fact pattern specific to that. I do know that we had one where the listing broker sat on the HOA board and was aware that there was going to be a special assessment coming down. And it was in the meeting minutes of the HOA. And initially, the real estate commission, because the listing agent didn't specifically say there's going to be a special assessment imposed, in 6 months, originally the real estate commission had voted to take action against that broker's license. But ultimately, when additional information kind of went back in front of the real estate commission, they decided that the listing broker hadn't faulted, that it was actually in the meeting minutes, and it was information that was available to the buyer. So it just really kind of depends on the fact pattern and what information is available, I think, at the time.
We have a bunch of questions kind of asking, and I don't know that we can go into every single one of them about like, is this a material fact? Is this a material fact? But there have been some general categories of questions, which lead you to believe that there might be a lot of barking dogs and horrible neighbors out there. But we've had questions about things that are adjacent to the property, like our neighbor plays loud music every Friday night, or the dog in back barks constantly. Has the commission sort of given guidance about facts like that?
So I don't think those are typically issues that the real estate brokers themselves, unless they are the ones that actually live in the property, those are typically issues that they're not aware of. And I think this speaks to several issues, because you also have Megan's Law that deals with sex offenders. So it's really in a buyer's best interest to spend some time in the neighborhood if they're looking at the property to get a feel. And I know that right now would be really challenging because we're all kind of on lockdown. But prior to the pandemic, I mean, go hang out in the neighborhood, after 5 when most people have come home, and kind of get the dynamics of it, or talk to the neighbors and see what they're like. I would also pull the contact history for the property that you're looking at. And while you're down at the police department pulling the contact history, you can also check to see where the sex offenders are at in the neighborhood, if that's a concern as well. But there's some due diligence that buyers can do to kind of get a feel for where they're looking at moving to.
And so you're saying that that's something that the buyers should do, or do you feel like that's something that the commission feels like the brokers should do?
So that's something a buyer should do. The brokers, by virtue of your Practice Act, don't have an independent duty to investigate. So you don't have to go out and investigate and find out if there's material issues with the property, or if there's neighborhood conflict. That is for the buyer to do.
And we've had some questions that sort of seem like they maybe dovetail with kind of competency questions as well. So, for example, there was a question, there are areas in this broker's geographical location that are subject to expansive soils, and any competent broker would know that. So would the listing broker have to disclose that, Or would it be considered a competency question on the buyer broker part?
Well, so one of the big issues that the brokers need to keep in mind is while your license is good anywhere in the state of Colorado, you do still need to be geographically competent for the areas that you're working in. So if you're going to go outside of your kind of regular area and you're venturing into an area that does have expansive soils, it's up to you to kind of learn the issues in that area. And, I know that Colorado has radon in its soil. So you can kind of generically make a disclosure of, well, we're known for having expansive soils, there's radon in the soil. If this is an issue to you, there's testing available. Now, if there's, like in our third case study where there's obviously issues, you're going to have to make specific disclosures about that property. That property had settling issues. It had expansive soils. That should have been specifically disclosed to those buyers.
And because it was a broker who owned it and listed it, right? Is that he should have known?
Double whammy if the broker had not been the owner in that case and didn't know anything about the history of what had gone on with that property, I wouldn't anticipate that the broker would have been disciplined. But unfortunately, in that scenario, it was a broker who was also the owner, and he was well informed about the issues with his property.
We've also got a bunch of questions about how the commission may have weighed in on problems that have already been remediated. So with regard to the meth lab question, when you were telling that story, there were a bunch of questions that came up. If it had been a remediated meth lab, how would that have changed the scenario?
Well, so several years ago, and I think it's well over 10 years ago, I believe there was a statute that was passed specific about meth lab mitigation. And if it's a meth lab that's been mitigated, the real estate broker doesn't have to disclose it. Now, that's specific to the meth lab issue. It's not specific to all material fact issues. And so the one thing that I would be a little hesitant about, and this kind of goes against the grain of the repeat business, is a few years ago, the Real Estate Commission considered a case. And the scenario was that the broker, this is the second time around that the broker has listed this property for sale. And the first go around, there were some issues identified. It was either with the foundation or with a chimney. Second go around with the listing, I don't know that the original issues had been mitigated or not, but the second go around, the real estate broker did not disclose the original issues. And the Real Estate Commission had said, because one of the questions we've always had with material facts is like, what is the span of time when a broker doesn't have to disclose anymore? And with that particular case, the Real Estate Commission came out and said, there's no limitation on time for disclosure. If you are aware of it, you have to continue to disclose. And for those of you that do a lot of business, particularly a lot of repeat business, I think that can make your lives really challenging because you now have to keep track of what all the different issues are, and it's regardless of whether they've been mitigated or not. Meth is just kind of the special one due to a state statute.
And we talk a lot about material facts as they relate specifically to listing brokers and the properties they are listing. Do you recall, have we had any kind of material facts about the buyers and the buy side of the transaction?
So the disclosure of material facts, and I know it also came up, is it just residential? It applies to all properties. So it's residential, it's commercial, vacant land, whatever the case may be. If there's a material fact, you have to disclose it. We have had some cases that have involved buyers and also tenants. So we had a scenario where it was a commercial property, the tenant was coming in. The landlord wanted to make sure about the financial fitness of the tenant to be able to perform the terms. It was a triple net lease. And so the landlord's broker had a credit check done of the tenant. And what had come up in the tenant's background was a prior bankruptcy. The broker didn't disclose that bankruptcy to the landlord. The landlord found out after the tenant signed the lease and then later defaulted on the lease. And then we got the complaint in at the Real Estate Commission, and the Real Estate Commission ended up disciplining that broker for failing to disclose the material facts about the tenant's finances. You've got the same issue with a broker. I mean, a buyer, if you've got a buyer that is not going to qualify for a loan and is not going to be able to pay cash because they don't have two nickels to rub together, but you're out there showing them $500,000 homes, you need to then disclose that they have no way of being able to finance this transaction. That would be kind of the disclosure for the buyer. And then with property management, we had one come up, I think it's been a couple of years ago, where the property manager didn't disclose to a prospective tenant that the prior tenant had had issues with bed bug infestation. And even though they had called in an exterminator, the exterminator wasn't successful at getting rid of the bed bugs. The new tenant moves in. Now all of that tenant's possessions has basically been contaminated by bed bugs, and he's having the effects of being bitten by them. And that was a case where the real estate commission disciplined that broker as well.
Yikes. Do you know, kind of in general, I mean, this is a topic that when it went out for people to sign up, we got a large response from brokers. How prevalent are these kinds of investigations in the number of complaints we get?
I would say probably, well, our most complained about has to deal with property management. They take up about 1/3 of our complaints. But I would say probably material facts, the failure to disclose those is in our top 5 of most frequent complaints that we receive.
And I know it's sort of early to try and make this determination, but do you know, will the presence of COVID be considered a material fact, do you think, or will the commission view it that way?
Well, so I think it's going to depend on the circumstances. I know that one of the questions was, what if you have somebody that dies in a property due to COVID? And I think it's a little different than a stigmatized property because contact is something to think of with COVID. So if you have somebody that you've got a property up for sale and the seller ends up dying due to a COVID-related death, I think you're going to have to look at the medical advice and also the CDC requirements as far as how do you deal with potential contamination of that property so that it's not a contagion anymore. And then once you've kind of overcome that hurdle, I wouldn't necessarily say that you have to disclose that there's been a COVID death. But I would hope that like you're also being respectful of the family, and it's not like, well, I need to book a showing tomorrow, even though your seller died today, because that's when you are going to encounter COVID-related issues.
I know we're kind of creeping right up and we want to be respectful of everybody's time. We're right at an hour. We did have just, maybe I can ask one more last question. There have been a bunch of questions about if the seller fills out the seller's property disclosure in a way that the broker knows to be inaccurate. Do we have any recommendation about best practices of how to handle that?
Well, I would be calling them out on that and letting them know that, okay, so you marked that there wasn't this issue and you've told me that there's this issue. So you can either fix that, or I'm going to be putting everybody on alert that no, this is what I've been told, and I'm disclosing the material fact. And I would cover your end in writing if you have to deal with something like that with the seller, because well, I guess at least that puts you on alert that you're going to have some challenges with that seller during the remainder of your relationship. If you have a chance to run away, I probably would at that point.
Sometimes it's worth it, huh?
Yes.
So we have, and I apologize to those questions that we weren't able to get to. We do want to be respectful of everyone's time. We said this would take an hour, and so we are at an hour. As Gary mentioned in the beginning, we do, following this, we'll have a frequently asked questions page at the division's website. This has been recorded. There are web pages that you can refer to. Gary, do you want to say anything else, or Marsha, anything else?
Well, I appreciate everybody's participation in these. I mean, we've got one more scheduled, and definitely, I mean, we value your opinions. So if there's a particular field that you would like us to cover, please let us know.
Thank everyone for attending. If you did have any technical issues with your bandwidth, we did have over 4,500 registrations. So this is recorded, so we will have it for you, and we'll send it out with the slides. And we just want to wish everybody a happy and safe holidays from the division, of course.
Definitely.
Okay. That's it. Thank you for attending.